Welcome back to the Deep Dive. We're the show that, well, we take these huge stacks of complex source materials.
Yeah, dense stuff.
Exactly. Today, it's the Texas Transportation Code, chapters 545, 550, plus some key bits from the Penal Code, and we turn it all into something you can actually use. Actionable knowledge.
Right. Our mission today is decoding the legal side of driving in Texas. It's a big code written for lawyers, really.
Very much so.
So we're going to boil it down. Key definitions, the rules, what's changed, and importantly, the difference between just getting a ticket and facing serious criminal charges.
Yes, that's the core. We're going deep on everything from, like, what exactly serious bodily injury means legally to when you have to report a minor accident. It's about building that solid foundation.
A necessary foundation.
Now, before we jump in, this stuff takes time and effort to put together. We do it because of your support. So if you find this valuable, please hit subscribe, help the channel grow.
It makes a difference.
And check out our website, too. We've got more resources, deeper dives there for you.
So today's mission starts at the bedrock. Before speed limits or anything else, we need the language of consequences. What do injury and intent mean under the Penal Code?
Because that's what everything else builds on, right?
Absolutely. If you don't get the difference between a basic offense and an enhanced one, well, you miss the whole picture of how Texas enforces these laws.
Okay, let's start with those high-stakes definitions. What happens when driving causes injury? We have to look at Penal Code 1.07. These specific words, they're the triggers.
Right. And the main trigger is injury itself. There are two levels. First, the lower one, bodily injury or BI.
Okay.
The definition is incredibly broad. Physical pain, illness, or any impairment of physical condition.
So not necessarily major trauma.
Not at all. Just causing pain is enough. It doesn't need a hospital visit, doesn't need stitches,
Yeah.
just pain.
How does that change, say, a traffic stop? Give us an example.
Okay, perfect one is the move over law, TRC 545.157. Normally, failing to slow down or move over for an emergency vehicle, that's a Class C misdemeanor, fine only. But let's say that failure causes a minor bump. An officer gets whiplash or even just scrapes their knee and needs a Band-Aid. That pain, that bodily injury, it instantly bumps the charge to a Class B misdemeanor.
Wow, so suddenly you're looking at higher fines, maybe even jail time.
Exactly. All because of that low threshold of physical pain.
Okay, that makes the stakes clear. Now, moving up, serious bodily injury, SBI. This sounds like where things get really bad.
They do. SBI is the top tier. It means bodily injury that creates a substantial risk of death, or actually causes death, or serious permanent disfigurement, or long-term loss or impairment of, an organ or a limb.
Heavy stuff.
This is the definition used for the state's most serious driving felonies.
And the classic example here is probably failure to stop and render aid, FSRA.
Absolutely. TRC 550.E021. If you're in a crash that causes injury and you leave the scene, the severity hinges on whether that injury meets the SBI definition. Well, if the state can prove serious bodily injury happened because of the crash, leaving the scene becomes a second-degree felony. If the injury is not SBI, the code calls it other injuries, it's usually a third-degree felony.
So the difference between SBI and just BI could mean, what, years in prison?
Potentially. We're talking the difference between a sentence range that maxes out at 10 years versus one that goes up to 20. It's a huge distinction based purely on the level of injury.
Okay, let's shift from injury to where things happen. So many traffic laws specify they must occur in a public place. Most people probably think, the highway.
Right, like I-35. But legally, it's way, way broader than that.
How broad are we talking?
Almost anywhere the public or, a substantial group of the public has access. So yes, streets, highways, but also hospital common areas, school grounds, shopping center parking lots, roads and apartment complexes, and those huge parking lots you see everywhere.
I think that's a big surprise for a lot of people. Why does that definition matter so much for, traffic stops?
It's the jurisdictional hook. Major offenses like DWI, DUI by a minor, reckless driving, they require the act to happen in a public place.
So if you're driving drunk on your own private ranch road, totally fenced off.
Probably not DWI under the statute, but the second you pull into the parking lot of that gas station on the corner, boom, you're in a public place. The law applies.
Wait a minute. So I could have a little fender bender in, say, a crowded Target parking lot during the holidays.
Yep.
And because that lot is legally a public place, that crash is technically a reportable crash.
Precisely. If the damage is bad enough that the car can't be driven safely or if someone gets hurt, even just that BI level of pain. It's not just about swapping insurance anymore. Because it happened in a public place, you might have a legal duty to stop, exchange info, maybe even report it.
Wow. So much for private property.
Legally, if the public has access, it's treated differently for these offenses.
Okay, huge point. Now, the really tricky part. Culpable mental states in fatal crashes. Distinguishing between manslaughter and criminally negligent homicide. This is about the driver's mindset, isn't it?
Exactly. Even if they didn't intend to kill anyone, the higher level is manslaughter. That requires the mental state of recklessly.
And what does recklessly mean legally?
It means the driver knew there was a big, unjustifiable risk and consciously decided to ignore it. That disregard has to be a gross deviation from how a normal, careful person would act.
Okay, let's use that Jim example from the source material. It helps draw the line.
All right. Scenario 1, Jim is driving the speed limit, 60 and a 60. It starts pouring rain. He hits a patch of water he didn't see. Hydroplanes crash. Passenger dies. Is that manslaughter?
Doesn't sound like it based on that definition.
Almost certainly, no. Driving the speed limit in rain. Yeah, it's risky, but is it usually a gross deviation? Probably not. His actions weren't legally reckless.
So if that's not manslaughter, how do we get to criminally negligent homicide? What if Jim driving is worse, but maybe not quite reckless?
That's criminal negligence. Here, the driver doesn't necessarily know about the risk and ignore it, but they should have known. They failed to see a substantial, unjustifiable risk that a reasonable person would have seen. It's often about a bunch of smaller bad decisions adding up.
Okay, let's revisit Jim. Give him a worse driving profile.
Scenario 2. Now Jim's doing 70 in a 60, and he's texting while driving. And his tires are totally bald, like a 132nd of an inch tread left. Same rain, same hydroplane, same fatal crash.
Okay, that combination feels different. Why does that likely meet the criminal negligence standard?
Because a reasonable driver should have known that speeding, plus being distracted by texting, plus driving on tires that unsafe, especially in the rain, that combination creates a massive, unjustifiable risk.
So it's the totality of the circumstances.
Exactly. Maybe no single act was quite reckless enough for manslaughter. But all those things together, speeding, texting, bald tires, that creates a risk Jim should have perceived and done something about. He failed to see the obvious danger his combined actions created.
That's a really important distinction, how those minor things can stack up legally. Okay, to wrap this part up, let's use that word association for the big intoxication felonies. Helps lock it in.
Good idea. For memory. Intoxication plus serious bodily injury, SBI. Intoxication assault, that's a third-degree felony.
Got it.
Intoxication plus death, intoxication manslaughter. That's a second-degree felony.
Okay, we've covered the criminal mindset stuff. Now, let's pivot to just the basic legal requirements to even be on the road. Registration, tags, license. This trips people up, especially new folks or those with, say, farm equipment.
Right. Starting with new residents, Texas gives you a little time. If you move here with current registration from another state, you can drive on that for a bit.
How long?
Not long. Once you're officially a resident, you have 30 days to get your vehicle registered in Texas. That clock ticks fast.
30 days.
Yeah.
And then you mentioned specialized stuff like farm vehicles. They have different rules, right? Especially for inspections and plates.
Yeah, big differences. Farm trailers, no matter the weight, don't need state inspections. That's huge.
No inspection at all.
No, but the registration and plate rules depend on the trailer's gross weight. And importantly, if it's only used temporarily on the highways, that just means driving, to or from the farm.
Okay, break down those weight tiers for farm trailers.
Sure. 4,000 pounds or less gross weight, basically exempt, no plate, no registration needed.
Easy enough.
4,001 pounds up to 34,000 pounds. This is the middle ground. You need a special farm trailer license plate, but not full registration as long as it's just temporary highway use.
Okay, farm trailer plate.
Over 34,000 pounds, exemptions are gone. These big ones need normal trailer registration, just like any other heavy trailer. That 34,000 pound mark is the key cutoff.
And it clears up a lot. Okay, let's talk violations. Registration and tags. There are these two similar sounding but different offenses for fake tags. Deceptively similar insignia versus fictitious registration insignia. What's the difference?
It really comes down to what is fake. Deceptively similar insignia. Think of a tag that looks real enough to fool someone, but it was never actually issued by the state. Like a homemade copy or something bought online that's not legit.
And the penalties for that one can get serious.
Oh yeah, just having one is a classy misdemeanor. But if you've been caught before, it jumps to a Class B. And if you're the one making or selling these fake tags, that's a third-degree felony.
Wow, okay, so that's the totally fake tag. What's fictitious registration insignia then?
This one looks real. It might even be an actual state plate or sticker. But the information tied to it is false. Like maybe you used fake info to get a real-looking sticker issued for your vehicle.
Ah, so the tag itself might be official-ish, but the data behind it is bogus.
Exactly. And that's handled differently as a Class B misdemeanor. So is the tag itself fake, deceptively similar? Or is the data behind a real-looking tag fake, fictitious? That's the split.
Got it. What about buyer's temporary tags? Those paper tags you get from dealers. Rules there.
Pretty strict. You only get one temporary tag per vehicle purchase. It's good for a maximum of 60 days. Getting a second one after the first expires is illegal.
And how do you have to display it? I see them taped inside windows sometimes.
Nope. It has to be legible, visible, and in the rear license plate spot.
Yeah.
Tucked away on the dash, rolled up, hidden. That's improper display.
And didn't a court case, Pabst v. State, say something about who's responsible for that display?
Yeah, that's important. The dealer has to put it on right initially. But that case clarified that once you drive off the lot, you, the driver, are also responsible for making sure it stays properly displayed. You can't just blame the dealer if it falls off or gets hidden later.
Good to know. Okay, let's switch to driver's licensing. First, the idea of the license itself. It's more than just the card, right?
Absolutely crucial point.
Mm.
Legally, your license is the privilege or authorization the state gives you to drive. It's not just the plastic card.
Why does that distinction matter so much?
It's key for charges like driving while license invalid, DWLI. Even if you never actually got a physical license card, the state can still suspend or revoke your privilege to drive maybe for unpaid fines or being underage. If they do that, and you drive anyway, you can be charged with DWLI because your privilege is invalid.
So, the state controls the privilege, regardless of the plastic. Okay. What about new residents getting that privilege?
If you moved to Texas, are 16 or older, and had a valid license from your old state, you've got 90 days to get a Texas license.
90 days.
But remember, the absolute minimum age to get any kind of Texas license, like a learner's permit or hardship license, is 15.
Okay. Now, the classes, A, B, C. How is that determined? Is it based on how much the truck actually weighs when it's stopped?
Nope, common mistake. It's all about the gross vehicle weight rating, GVWR, or for combinations, the gross combination weight rating, GCWR.
The rating on the sticker.
Exactly. Set by the manufacturer, usually on the VIN sticker inside the door jamb. It doesn't matter if the truck is empty or full or what it's registered for. The rating determines the license class needed.
So even if I register my big truck for less weight, I still need the license matching its rated weight.
That's the law. The rating is king. Class C, standard license. Cars, light trucks, what most people have. Class B, needed for big single vehicles. Think dump trucks, large RVs, buses. Specifically, a GVWR of 26,001 pounds or more, or any bus built to seat 24 or more people, including the driver. Class A, the top tier, usually for combinations. Required when the combined rating, GCWR, is 26,001 pounds or more, and D, the trailer being towed, has a GVWR over 10,000 pounds. Both conditions have to be met.
Give us that Class A example again. It catches people.
Sure. Big pickup truck rated at, say, 10,000 pounds GVWR. You hook up a huge fifth-wheel trailer rated at 17,000 pounds GVWR. Your combined rating is 27,000. That's over 26,001, and the trailer is over 10,000.
Here you go. You need a Class A license, even if it's just for camping trips. Okay. Lastly, in this section, occupational licenses. These are for people whose regular license is suspended, right?
Yeah, it's a special restricted license. You have to go to a judge and prove an essential need to drive, basically, for work, school, or maybe critical family duties like doctor visits. It's not a free pass.
And messing up with an occupational license has big consequences.
Very big. Violating the terms is a Class B misdemeanor, and if you're convicted, they revoke the occupational license completely.
What are the common ways people violate it?
Two main ways. One, not carrying a certified copy of the actual court order with you while driving. That order is the license, but only for 45 days until the state issues a card. Two, breaking any restriction listed on the order, driving outside the allowed times, taking a different route than approved, or disabling a required ignition interlock device.
Okay, we've got the vehicle legal, the driver licensed. Now, Chapter 545, the actual rules of driving. And these rules often have legal quirks.
They definitely do. Let's start with slower traffic keep right. 545.051. Everyone thinks left lane is for passing only.
But it's not quite that simple for getting a ticket, is it?
Not exactly. The violation is specifically slower vehicle fail to keep right. To commit that offense, there has to be other traffic on the same road going faster than you are.
So if I'm doing the speed limit in the left lane, but there's no one else around.
Technically, under this statute, you haven't violated it. The law is aimed at preventing drivers from impeding faster traffic, not just dictating lane choice in a vacuum.
Interesting nuance. Okay, another big one. Driving in a single lane. 545.060. There was a major court case, Hardin v. State, that really changed how this is enforced.
Huge case. It significantly impacts traffic stops. The law says you have to drive as nearly as practical entirely within a single lane and may not move from the lane unless that movement can be made safely.
The key word there is and.
Exactly. The court said because of and, the two parts are linked. You can't separate them.
So what does that mean practically, if I just touch the line for a second?
It means just briefly touching or drifting over the lane line. That's not automatically a violation. For the offense to happen, you have to move out of the lane, A&D. That movement must have been unsafe.
So if an officer sees my tire touch the white line, but there's no other traffic, no danger, that's not a valid reason to pull me over based on this law.
According to the Hardin precedent, no. The movement itself has to be unsafe. That ruling gives drivers a lot more leeway for minor, momentary drifts.
Okay, that's a critical point.
Yeah.
But what if an officer sees someone driving erratically, but maybe not quite making an unsafe lane change? Like they suspect the driver's impaired or having a medical issue. How can they intervene without a clear violation?
That's where the community caretaker doctrine fits in. It's an exception that lets police stop someone without suspecting a crime, purely out of concern for public safety or the driver's well-being.
Like a welfare check.
Essentially, yes. But they can't just stop anyone. Texas courts set up a 4-part test the officer needs to consider.
Okay, what's the test? Let's use an example.
All right, imagine an officer sees a car pulled onto the shoulder of a dark, empty highway late at night. Hazard lights are on, driver slumped over the wheel. No obvious violation, but something's wrong, the officer thinks. 1. Level of distress. Slumped over looks like high distress versus someone just texting. High distress supports the stop. 2. Isolation. Empty rural highways isolated. Less chance of other help arriving. Supports the stop. 3. Alone. Is the driver alone? If so, they're more vulnerable. Supports the stop. 4. Danger. Is the situation dangerous? Yes. Stopped on a highway shoulder at night is risky. Supports the stop.
So if the officer can justify those points,
then they likely have a valid stop under community caretaker, even without seeing a specific traffic offense. The goal shifts from enforcement to checking welfare.
Makes sense. Okay, let's talk about the move over law again. 545.157 gets a lot of press. Who exactly is protected now?
It's a pretty long list. Stationary emergency vehicles with lights on, stationary tow trucks with flashing reds or ambers, and stationary TXDOT or highway maintenance vehicles using amber or blue lights. Basically, anyone stopped and working near the road.
And what exactly does the driver have to do?
One of two things. You must either move over one lane away from the stopped vehicle, if you can do it safely, or if you can't move over, you must slow down to at least 20 mph below the posted speed limit.
Okay, here's the key question. What if I slow down by 20 mph, but I could have moved over easily and just didn't? Am I still good?
No, and that's the critical part people miss. Moving over takes priority. If you can safely vacate the lane next to the stopped vehicle, you must. Slowing down is only the alternative if moving over isn't possible or safe.
So failing to move over when you could have is a violation, even if you slowed down.
Correct. And the fines are steep, starting around $500, and it escalates fast. Plus, remember our earlier discussion. If you cause bodily injury doing this, it can become a felony.
Right. Okay, next up, driving on improved shoulders. That paved part on the side of the road, not a driving lane, right?
Definitely not, unless you meet a specific exception. An improved shoulder is just a paved shoulder.
And there are different rules for the right shoulder versus the left.
Yes. The right improved shoulder has 7 exceptions. The mnemonic SAD pay key helps. Stop, stand, or park. Accelerate to merge into traffic. Decelerate to make a right turn. Pass a vehicle that's slowing, stopped, or disabled. Allow a faster vehicle to pass you. Permitted by a sign or signal, like use shoulder when flashing. Avoid a collision.
That's quite a list. Did that Lothrop v. State case clarify the pass part?
It did. The court interpreted pass pretty broadly, meaning you can use the shoulder briefly to get around various things, slowing or stopped in the main lanes, not just, a car with a flat tire.
Okay. And the left improved shoulder? Much tighter rules.
Way tighter. Only 3 exceptions. Remember SPA. Slow or stop only if your vehicle is disabled. Permitted by an official sign or signal. Avoid a collision. That's it. You can't use the left shoulder to pass or let others pass.
Good distinction. Okay, wrapping this section. Traffic signs and signals. People might not realize a construction zone speed sign isn't the same as a regular speed limit sign.
Big difference in enforcement. Obeying warning signs and barricades means you follow those orange construction signs, or directions from a flagger who is legally defined as a warning sign.
So if a sign says speed limit 40 when workers present, and I do 50 past workers.
The violation is disregard warning sign, not speeding, because it's a conditional warning, not a permanent regulatory speed limit. Different offense, different potential penalties.
Okay, and stopping. Stop signs, flashing reds. Where exactly do you legally have to stop? Is it at the sign?
Never at the sign itself. The law gives 3 specific spots in order of priority. 1, at the stop line, that painted white bar on the road. 2, if no stop line, then before entering the crosswalk. 3, if no line and no crosswalk, then at the point closest to the intersection where you can actually see the crossing traffic clearly.
So visibility or markings dictate the spot.
Whichever comes first, stop line, crosswalk, or point of visibility.
And what if a traffic light is completely out? Power failure.
If the whole signal head is dark, no lights showing at all, you treat that intersection as an all-way stop. Everyone stops and follows the normal right-of-way rules.
Like a 4-way stop sign.
Exactly. Unless it's one of those special pedestrian hybrid beacons or ramp meters, a dead signal means stop.
Right. Final section. Safety stuff, equipment rules, and what to do after a crash. Let's start with safety belts and child seats.
Okay. Child seats. The rule is they're needed for kids younger than 8 years old, unless the child is already taller than 4'9".
8 years old or 4'9".
Got it.
And regular safety belts.
Required for everyone in any seat that actually has a belt installed.
Now, who gets the ticket if someone's unbuckled? This gets confusing.
It depends on the passenger's age. If the unbuckled passenger is 15 or older, they get the citation. They're considered responsible for themselves.
Okay.
But if the unbuckled passenger is younger than 17, then the driver gets the ticket for not ensuring the child was restrained.
So if I have a 16-year-old in my car who won't buckle up, technically both of us could get cited.
Technically, yes. Although, officer discretion usually means only one citation is issued, often to the driver if the passenger is under 17.
Any weird exceptions to the seatbelt rule?
A couple stand out. The driver of a farm truck is exempt, but their passengers aren't. Also, passengers paying for a ride in a taxi or limo are exempt.
Okay. Moving to vehicle equipment. Let's hit window tint. Always a hot topic. What are the limits?
For the driver's window and the front passenger window, the tint has to let 25% or more of the light through. And it can't be too reflective, 25% or less reflectance.
So pretty light tint allowed up front.
Right. If you can barely see the driver, it's probably too dark.
Now, what about the back windows? There's some confusion here, especially with out-of-state cars. For a Texas-registered car.
For a car registered in Texas, the side window's behind the driver. So rear doors, back window can basically be as dark as you want. That part of the law doesn't limit tint on those windows.
You could black them out completely.
Legally, on a Texas-registered vehicle, yes, for those rear windows.
But what if the car is registered in, say, California and driving through Texas?
Ah, that's the key. If the vehicle is not registered in Texas, then the Texas tint law doesn't apply to it at all. So if someone from a state with darker tint rules drives here, their tint is legal here too, as long as they're not actually a Texas resident violating registration laws.
Okay, that clears that up. Next, mud flaps or safety guards. Required on what and how low do they have to be?
Required mostly on bigger trucks, especially ones with dual rear wheels or those super single tires. They hang behind the back wheels to stop rocks and spray. The law says they have to be within 8 inches of the ground.
8 inches. Seems tough with bouncing suspensions. Is there wiggle room?
There is. The administrative code allows a 4-inch tolerance. So when the truck is parked, officers measure, and if the flap is within 12 inches of the ground, it's considered compliant.
12 inches when still. Good to know. Who's exempt?
Truck tractors driving without a trailer, bobtailing. Pole trailers, RVs, and buses generally don't need them.
Okay. And quickly, mufflers and emissions.
Muffler has to be in good working order. No cutouts or bypasses designed to make it louder. For emissions, if your vehicle is a 1968 model or newer, it can't emit visible smoke for 10 seconds or longer.
10 seconds of visible smoke. Got it. Okay, let's talk duties following crash. Chapter 550, what's the absolute first legal requirement?
Knowledge. To be charged with leaving the scene, like Failure to stop and render aid, FSRA. The state must prove you knew a crash happened. That came from the Baker v. State case.
So if it was a tiny scrape you honestly didn't feel?
It makes prosecution very difficult. You have to know you're in a crash.
Okay. Assuming you know, how does the law break down fleeing the scene based on damage versus injury?
It uses those Bisbee definitions we talked about, FSRA felony. If any injury occurred, death, SBI, or just BI, pain leaving is a felony, second or third degree, FSRA misdemeanor. If it's only vehicle damage and the other vehicle was attended, someone was with it, leaving is a misdemeanor. Class C if damage is under $200, Class B if it's $200 or more, striking unattended fixture. If you hit a parked car, mailbox, fence, you have to stop and leave your info. Not doing so is a Class C or B misdemeanor, again, based on that $200 damage threshold.
And when do you actually have to report the crash to the police? Not always, right?
Correct. A formal police report is only legally required if the crash resulted in injury or death, or if the damage was so bad the vehicle can't be normally or safely driven away. Minor fender benders, where everyone drives off, usually just require exchanging info.
Okay. Last two specialized rules. Motorcycles and helmets. What's the rule now?
Helmet required for rider and passenger unless they are 21 or older, A and D. They meet one of two conditions. Either they've completed a state-approved safety course, or they have specific health insurance coverage for motorcycle accidents.
So, under 21, always helmet. 21 or older. Helmet unless you have the course or insurance.
Exactly.
And finally, that important update on privileged parking for disabled veterans.
Yeah, big change from January 1st, 2022. Just having a disabled veteran DV license plate is no longer enough to park in a disabled spot.
What do DV plates need now?
The plate itself must now feature the international symbol of access the wheelchair symbol. If your DV plate doesn't have that symbol, you don't get the parking privilege automatically.
And one more point about those spaces.
Right. The violation is illegally parking or standing. Briefly stopping in the space just to drop off or pick up a person with a disability is explicitly not considered standing, so that's allowed. Hashtag outro.
And that wraps up a very deep dive. We went from criminal intent definitions all the way to mudflap height and parking rules. Knowing these specifics really matters.
It does. It separates an informed driver from one who's, frankly, at risk legally without realizing it.
It all connects back to responsibility, doesn't it?
Yep.
Financial and legal.
Which brings us to a major legislative shift we need to mention. The repeal of the Driver's Responsibility Program, the DRP.
Ah, yes. The DRP, Chapter 708. That was controversial. It added huge annual surcharges on top of fines for things like DWI, no insurance, driving while invalid.
For years sometimes. It was criticized heavily for trapping people, especially lower-income drivers, in debt, making it almost impossible to get their license back legally.
But it's gone now.
Completely gone. Repealed September 1st, 2019. All the old DRP debts were wiped clean and they stopped assessing new ones. Huge relief for a lot of Texans.
Okay, so if that program, the state's main tool for long-term financial punishment for bad driving, is gone, how does that change things today? Where does that accountability fall now?
Well, the burden shifts, you know. Without those long-term surcharges, the consequences fall more heavily on the immediate penalties. Higher fines, potential jail time, civil lawsuits. And the criminal charges themselves can escalate more directly based on the circumstances. Remember DWLI, driving while license invalid? If you commit DWLI and you're uninsured, and you cause a crash resulting in serious bodily injury or death, using those definitions we covered, that DWLI charge jumps straight to a Class A misdemeanor. Serious jail time potential.
So the immediate legal hammer is heavier now, perhaps?
In some ways, yes. Without the DRP's slow financial squeeze, the state relies more on those upfront criminal penalties and civil liability to deter high-risk behavior, especially from repeat offenders or uninsured drivers. It raises this ongoing question for the state. How do you hold drivers accountable, especially for serious risks, while still providing pathways for people to legally drive, which is essential for most people's lives? Removing the DRP really changed the dynamics of that balancing act.
So the final thought for you, the listener. With the DRP gone, does the current system of immediate penalties and potential civil suits effectively deter risky driving? Or did removing that long-term financial pressure leave a gap in accountability? It's something to think about how Texas continues to balance the privilege of driving with the immense responsibility that comes with it.
A complex balance indeed.
Thanks for joining us on this deep dive. We'll catch you next time.